So up until the end of 2019, there was no overarching law on the protection of personal data in Kenya. A number of laws, however, did and continue to contain provisions that relate to the protection of personal data, including the Access to Information Act, the Consumer Protection Act, as well as the laws that regulate the communication sector. So the Data Protection Act lays out the rules for processing or handling personal data, which is essentially any data which relates to an identified or identifiable natural person. So corporate entities like companies and other juristic persons are excluded from the definition of a data subject under the Data Protection Act. A person's name, their ID number, their email address, their physical address, their PIN number, and many other identifiers fall under the ambit of personal data under the Kenyan Data Protection Act. The general rule is basically that the handling or processing of personal data is prohibited, except where certain grounds for the lawful processing of that data exists, or where the application of the prohibition under the Act is exempted. So one prominent ground for lawful processing of personal data is the consent of the data subject. Certain activities are exempted from the Data Protection Act and its requirements. For example, the processing of personal data of an individual in the course of a purely household activity. Other matters that would be exempt would be, where the processing is necessary in the public interest or for, say, national security. So the Kenyan Data Protection Act generally applies to the processing of personal data that's entered in a record through automated or non-automated means. It also applies to the processing of personal data by persons, both natural and juristic persons, who are ordinarily resident in Kenya or who are established here. It applies to the processing of personal data by persons who are located outside Kenya, where the personal data that they process relates to natural persons who are within Kenya. And to this extent, it's advisable for foreign-based persons who handle personal data relating to Kenyan data subjects to acquaint themselves with the obligations under the Data Protection Act in Kenya and to put in place measures to ensure compliance. The Data Protection Act provides for administrative remedies in the form of enforcement notices and penalty notices. It also provides for criminal and civil sanctions. These remedies could be enforced against data controllers or processors who are not resident or established in Kenya, but who process data that relates to subjects who are in Kenya. And any civil awards given by Kenyan courts in respect of the breach of a data subject's rights, for example, could be enforced through foreign courts in certain countries. Examples are the United Kingdom and Australia. The Commissioner also has power under the Act to enter into an association with bodies or organizations both within and outside Kenya so as to achieve the objects of the Act, including enforcement. The extradition to Kenya of foreign offenders for purposes of criminal trial could be an option in the future if necessary amendments are made to the relevant extradition laws so as to designate offenses under the Data Protection Act as extradition offenses. So, due to the many similarities between the General Data Protection Regulation in the EU and the Kenyan Data Protection Act, compliance with the GDPR's requirements could give some comfort to such foreign-based data handlers. But there are some unique requirements under the Kenyan Data Protection Act that would require foreign data handlers to take a closer look at the Kenyan Data Protection Act and to possibly supplement their compliance measures in relation to the processing of personal data belonging to data subjects who are in Kenya. So, for example, one such unique requirement is the requirement for the registration of certain controllers and processors. And this is subject, of course, to the issuance of regulations setting the threshold for registration. But I suspect that this will be one of the first regulatory aspects of the Kenyan Data Protection Act that the Commissioner will seek to operationalize.